Good morning and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Tulo Hoyane. A lot of people have been asking me, can anything be done given what we see in the Meyiwa trial? Given all the irregularities that we see going on there, is there anything at this stage before the trial even comes to an end? Normally, or the normal procedure is a trial will run its course, and then when it is done with, people can always take matters on appeal. But there's such a clamor, of dissatisfaction about the way the trial is proceeding. And I said to myself, let me give my viewers and subscribers some feedback as to what can happen now. So all is not lost. Something can be done now as I speak. We don't even have to wait for the end of the trial. What has to happen? There's Section 317 of the Criminal Procedure and Evidence Act of 1977. Without getting into too many legal intricacies, let me just explain 317 in this manner. If any person appearing in any trial feels that the trial is not being conducted according to law or according to the law, that person can make an application by way of what is known as a special entry. In other words, the lawyers in the Meyiwa trial can simply indicate to the judge that they want to make a 317 application and make it right there and there. And after they've made the application, before the same judge that they are complaining about, you see, that's the difficulty of it, because it has to be made before the presiding judge. So that this application, if it is made by the defense lawyers, it will be made before Justice Ratamokgotle. In the event that this application is denied, this matter can be taken on appeal to the Supreme Court of Appeal in Bloemfontein. Now, what impact will this have on the trial? It will mean that the trial will have to stop. The trial will have to be stopped until the finalization of those applications. If need be, the last application may be in the Supreme Court of Appeal, or even then the matter can be taken further to the Constitutional Court. So something can be done about the irregularities that we are seeing. Let me remind you of an incident some time back when the late Mngomezulu told the judge in court point blank, that you are not impartial. Mngomezulu told him that. That is why they call Mngomezulu the bulldog. Mngomezulu told him, you are not impartial and I intend to bring a 317 application. I remember Mngomezulu even, sort of slipped and said the section is 371, and the judge mockingly said, no, 317. Anyway, Mngomezulu was making that application. How sad it is that Fulani Mngomezulu had to leave that courtroom and this world. But this is where we are now. We have chronicled so many irregularities, right? Now it is up to the defense to take up those irregularities by way of making an application as soon as now. When the case resumes on the 20th, they can simply cite all these irregularities and use them as evidence in support of their application, in terms of Section 317. That is the remedy that the defense has. And I'll be in the Pretoria High Court. I'll try and get in touch with one or two of them to impress upon them the need to, bring up or come up with a 317 application. I think this is the only cure. This is the only thing that can be set people's, hearts at, at rest, so to speak, because, the way the process is going, let alone the fact that we are not satisfied with the docket in terms of which these people are being charged. But the way the judge is conducting this trial, I have said over and over again, leaves much to discuss, to desire. The disparaging demands that he has made, the overt way in which he leans towards the prosecution. Every time there's an objection, he does not make a ruling, but he just keeps on going and on and on and on and on and on as if nothing has happened. So the only remedy to put a stop and a huge full stop on this is Section 317 of the Criminal Procedure and Evidence Act. I want to see these people do that. I want to see the defense do that. I want them to carry the baton from where Mngomezulu left off and stand up in that court to say, we are not satisfied with what we are seeing here. This is not justice. These are irregularities. And these things cannot be allowed to go on. Well, chances are in an application like that, because you are going to make it before the same judge against which you are complaining. You are the complainant, and the judge, the person against whom you are complaining is the judge, and the judge also has to make the decision in that application. Chances are, and experience has taught me that that same judge will simply dismiss that application. But that does not matter. You still have a right of recourse to the Supreme Court of Appeal in Bloemfontein. And even beyond the Supreme Court of Appeal in Bloemfontein, I've said earlier on, there's the Constitutional Court. So there you have it. We all have a solution. We all have a solution. Nothing is lost. And as soon as now, if these things could be done now, I think that we will see a lot of changes in the Meyiwa trial. At least, well, in terms of 636, I don't believe in docket 3636. But if they're going to run it, a trial in terms of docket 636, they better run it, in such a way that it looks like a trial and conforms to the standards and, expectations of what a trial is all about. It cannot just be conducted in the manner that we see it being conducted now in the Pretoria High Court. So that is the solution. Let me get your comments in the comment section. I'm very encouraged by the comments that have come from the last video. Like I said, I'm moving full steam ahead. Nothing will stop me. Thank you for those beautiful comments, and so thank you for all those encouraging comments. For those of you who have not yet subscribed, please kindly do so, subscribe, and have a nice day. Thank you very much.